Hello, I'm David Hertzell, and I am Senior Counsel at the Commercial and Common Law team at the Law Commission. Here at the Law Commission, we are asked to review the law to ensure that it is fair, modern, simple and cost-effective. One area we are currently reviewing is a law that relates to friendly societies. Friendly societies are organisations that are owned by and run for the benefit of their members. Historically, they may well have been little more than social and drinking clubs. However, these days, they can and do provide financial benefits to their members or their members' families. They can provide insurance benefits, such as life or health insurance, for example, in which case they operate similarly to regular insurance companies, except that they do not have outside investors to whom they have to pay dividends. Friendly societies have a long and proud history in the UK, dating in some cases back to the 1700s. Today, many focus on members who might find it harder to access commercial insurance products sold by mainstream commercial companies. So what are we doing? As I said, friendly societies have been around a long time, and much of the law that applies to them is now quite old. The most recent law dates back to an Act of Parliament from 1992, and much of it is earlier, and in particular from an Act in 1974. Clearly, a lot has happened since then, and friendly societies have told us that the law needs to be updated. We have just published a consultation paper on friendly societies that sets out the law as it currently stands, along with provisional proposals for law reform, and we ask questions as to how things might be improved. The Law Commission is a highly consultative body, and we take our consultees' views very seriously indeed. We can and often do change our minds in response to the opinions and feedback that we receive. Many of the topics we discuss are generally focused on modernising the law for friendly societies. So we talk about electronic communications with members, electronic submission of annual accounts and other documents that are required, and updating the list of things that friendly societies must include in their rules. Things that the law could facilitate to help friendly societies function more effectively in the 21st century. We also look at simplifying some of the things for friendly societies that seem unnecessarily difficult or complicated, such as rules relating to audit work and accounts, especially for small friendly societies, and there are a very large number of such societies, or standardising notice periods for meetings. We look at voting requirements for transfers of business and simplifying the process for amalgamation of two or more societies. We consider the limitations that are placed on the kinds of business a friendly society can undertake. And we make provisional suggestions for some restrictions to be removed, such as the restrictions on reinsurance and on writing group insurance business. We also look at a few very big topics, such as demutualisation and the protection of legacy assets acquired by friendly societies over many years, and how friendly societies are permitted to raise money. Some societies that are technically not friendly societies, but organisations such as working men's clubs or benevolent societies, are registered under the 1974 Act, along with traditional friendly societies. No new societies of any type whatsoever can be registered under this Act, which is now clearly 50 years old. We ask whether there are more suitable and modern ways for the law to apply to these organisations, such as, for example, the Cooperative and Community Benefit Society Act 2014, which is obviously a more recent piece of legislation. Most of our proposals are technical and aimed at improving the efficiency and sustainability of friendly societies. But the question of demutualisation, how a friendly society ceases to be a society but becomes instead a mainstream company, and how friendly societies raise external money to expand their businesses, These could have much bigger ramifications and implications for the growth and protection of the sector, which the government is committed to doing. These are only some of the issues we address in the paper, some of the most important ones we wish to bring to your attention. If you're interested in knowing more about any of these issues, or if you have concerns about the law that relates to friendly societies more generally that we may not have mentioned here, please read our consultation paper, our shorter summary paper, or our separate fact sheet for members. The consultation period will run until the 11th of June, and we encourage people to respond electronically to our questions if at all possible. We will, though, review all replies, however they are sent. People are welcome to only answer certain questions, as we appreciate not everything is of interest to everybody, and not everybody will have a view on every one of the issues that we discuss. We very much hope that you will be able to assist us in formulating those recommendations and to improving the law for friendly societies generally.